Everything that is explained in this video is summarized from CoinMarketCap. And also, please don't forget to support my channel for more XRP updates and some other cryptocurrencies as a whole. Now, take a look at this. Ripple versus SEC ongoing legal battle intensifies with new allegations. It is impossible to make any predictions about what is happening in the Ripple versus. The XRP community has been waiting for its win for a considerable amount of time, and each day brings a new twist and turn to the situation. On the other hand, the Securities and Exchange Commission, the CSCY, in the back with deceptive attitudes and unjust methods, despite Ripple's assertions that the SEC seeks to overreach cryptocurrency with confusing legislation. Stuart Alderity, the chief legal officer, Colo Ripple, has lately voiced his disapproval of the way the Securities and Exchange Commission has handled the XRP case. He has brought attention to what he considers to be unfair tactics and broader challenges for the cryptocurrency industry. There is no need for innovation to be a partisan issue. I am relieved to see that Democrats and Republicans can reach a consensus on at least one issue. Gensler's Securities and Exchange. After a protracted conflict with the Securities and Exchange Commission (SEC), Alderity discovered some intriguing similarities between the behavior of the SEC and the absurdities depicted in Franz Kafka's novel, The Trial. He accused the regulator of engaging in illegal activities. Ripple thinks that the approach used by the SEC is unfair and lacking in transparency, which is reflective of broader problems that other cryptocurrency companies such as Robinhood and Coinbase are experiencing. Legal strategy employed by Ripple through the filing of requests to seal crucial financial documents in preparation for their release to the public. Ripple has taken measures to protect its interests. The records in question contain essential information regarding earnings, revenues, and expenses, as well as the discounts that were offered to institutional investors when XRP was sold to them. Ripple contends that the disclosure of such information would be detrimental to its commercial interests and would put users' privacy at risk. Following this, the Secretary of the Securities and Exchange Commission has demanded that Ripple pay a penalty of $2 billion for allegedly selling XRP institutional investors. The legal team representing Ripple, on the other hand, maintains that any civil penalty should be limited to a maximum of $10 million, stating that CC's demand is not justified. Furthermore, they argue that Ripple should not be compelled to pay this substantial sum by employing illegal strategies because there is no loss of customers. Greater concerns regarding regulations. The criticism offered by Alderity bring to light the greater issues that exist within the cryptocurrency industry between the enforcement of regulations and the operations of businesses. The Securities and Exchange Commission has provided Ripple and other cryptocurrency companies with what they describe as inconsistent feedback, which has made it more difficult for them to comply with regulatory obligations. A reaction from legislators. As a result of the legal dispute involving Ripple, moves within the United States government to restrict the SEC's regulatory authority have been brought to light. To limit the impact of the Securities and Exchange Commission SEC on cryptocurrency legislation, Alderity has lauded collaborative efforts in the House of Representatives. Notably, the House of Representatives recently voted to repeal the staff accounting issued by the Securities and Exchange Commission. This bulletin requires financial institutions to include the cryptocurrency holdings of their customers on their balance sheets. What this means for the cryptocurrency industry. Ripple's lawsuit against the Securities and Exchange Commission (SEC) is a major for the cryptocurrency industry as a whole. It is important to note that the SEC has also questioned Ripple's future stablecoins, which makes their aim more transparent. There's a possibility that the conclusion will establish precedents for regulating digital assets. Finally, the allegations that Alderity has made against the SEC are unmistakable and important. The triumph of the SEC will have a negative influence on the cryptocurrency market, since the classified status of XRP as security will force many other assets to be burned while they wait for similar rulings. During the continuing legal struggle between Ripple and the United States Securities and Exchange Commission, Stuart Alderity, the chief legal officer of Ripple, has compared the acts of the SEC to the follies that are represented in the novel, The Trial, written by Franz Kafka. During the inquiry and the Wells notice process, Alderity criticizes the Securities and Exchange Commission for what he considers to be an unfair treatment at XRPVs. This suggests that the problem is more widespread and affects other cryptocurrency companies such as Robinhood and Coinbase. Clo of Ripple criticizes the inconsistent actions taken by the SEC. Ripple has maintained its position that the SEC's handling of the issue has been characterized by inconsistency and injustice throughout the ongoing proceedings. The allusion to Kafka's work that was made by the chief legal officer of Ripple is a sharp criticism of what Ripple considers to be the opaque and arbitrary acts of the regulator. The SEC frequently provides cryptocurrency companies with contradictory comments, and Ripple believes that this particular situation is illustrative of the more widespread difficulties that these companies confront. Other businesses, like as Robinhood and Coinbase, have also reported encountering regulatory obstacles of a similar nature. Ripple is still being pursued by the Securities and Exchange Commission, set for significant penalties, and the SEC is requesting over $2 for selling XRP institutional investors. Ripple has replied by filing and sealing some documents highlighting the possible damage that may be done to its business interests if particular financial facts were made public. Ripple has requested that certain sensitive information be redacted, including information regarding profitability, revenues, expenses, and the discounts at which XRP was sold to institutions. Ripple is unwilling to divulge the specific financial conditions, citing the need to maintain commercial secrecy, even though it acknowledges the significance of these discounts. Actions taken by the House against the excessive regulation of cryptocurrency. Additionally, Ripple's move to seal papers aims to protect the identities of non-party financial institutions, clients, and staff of the company. The company contends that disclosing this information could put legitimate privacy interests at risk and could also be detrimental to business partnerships. The position taken by XRP is that such disclosures would not only have an impact on its partners, but they would also make it more difficult for the company to function efficiently in the market. Despite the substantial demands made by the SEC, XRP reiterates that any civil penalty should be limited to a maximum of $10 million. The fact that Ripple holds this position is a reflection of the company's conviction that the SEC's pursuit of $2 billion is unnecessarily severe and does not accurately reflect the fact. The arguments presented by Ripple shed light on the broader issues that exist within the cryptocurrency industry between the enforcement of regulations and the operations of businesses. The court case involving XRP has brought attention to the more comprehensive regulatory approach taken by the SEC. In the United States House of Representatives, bipartisan efforts to curb the Securities and Exchange Commission's overreach in Bitcoin regulation have been commended by Stuart Alderodi. A recent vote in the House of Representatives was successful in overturning the Staff Accounting Bulletin No. 121, AB 121, issued by the Securities and Exchange Commission. This bulletin mandates that financial institutions must reflect the cryptocurrency holdings of their customers on their balance sheets. When it comes to Ripple Labs, the legal battle is becoming increasingly heated. Following Ripple's decision to withhold some papers from public disclosure, the case brought before the United States Securities and Exchange Commission, its SCAS, becoming increasingly intense.